Hello, everyone, and thank you for attending today's webinar, Recent Developments in Labor and Employment Laws and an Analysis of the Recent OSHA Vaccine Mandate Rule. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or if we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. If your screen freezes during the presentation, you can select the F5 key to refresh your screen. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited in California and Illinois for 1.5 hours of general credit. Missouri is approved for 1.8 hours of general credit. New York, transitional and non-transitional for 1.5 hours of areas of professional practice. And in Texas, we have 1.5 hours of general pending. The webinar is approved for 1.0 hours of SHRM credit and 1.0 hours of HRCI is pending. We award CLE based on attendance for the entire 90 minutes. Due to changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance check. As required, we will display secret words in 3 multiple-choice polls during the webinar. You will be required to select today's secret word from a multiple-choice list. Please respond to these 3 polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in this course. Today's agenda will consist of the following. First, Conor Neusel will talk about common wage and hour mistakes and provide an update on the new rule for tipped employees. Then Krissa Lubben will give us updates on Missouri's and Illinois' leave laws for victims of domestic or sexual violence. I will then cover an Illinois employment law update, including changes to background checks, as well as the use of restrictive covenants and changes in the Illinois Equal Pay Act requirements. And finally, we will turn over to Dave Dieterding, Amy Oslika, Colin Pajda, and John Viola to cover an analysis of the recent OSHA Vaccine Mandate Rule. We will provide an opportunity for questions at the end, but as we've already stated, please feel free to add questions to the Q&A box throughout the course of today's webinar, and we will do our best to answer them in real time. With that, I will turn it over to Conor to talk about the Fair Labor Standards Act.
Good morning, and thank you, Susan. We're going to start this morning with a quick review of the Fair Labor Standards Act and specifically some common mistakes to watch out for. And then we'll look quickly at the new rules for employers that have tipped employees. The FLSA, as you know, requires most businesses to pay, the FLSA requires most employers to pay employees a time and a half for their regular rate of pay for all hours worked beyond 40 in a work week, unless, of course, they fall into an exception. The most commonly used exceptions are the administrative, executive, and professional exceptions, which are collectively known as the white-collar exceptions. Now, misclassifying employees or miscounting their hours and pay rates can result in very costly lawsuits for employers. And with the COVID-19 pandemic, it's created more wage and hour issues for employers, especially because employers have shifted to remote work. One fairly common, and I'd say the most common and costly error that employers will encounter is misclassifying employees, classifying them as exempt when they're actually not. Now, employers can protect against this by conducting an audit, or at least, as I recommend often, conduct an audit of those fringe positions. Some positions are going to be much clearer than others, and if there's any question in your mind, or if it's been a little bit of time and there's been some changes in job duties, especially with the shuffling of the workforce that I'm certain that most employers have undergone throughout this last couple of years, it's never a bad time to audit some positions and make sure that you are correctly classifying. Now, to fall under the white-collar exceptions, employees must meet 3 tests. They have to be paid on a salary basis. That means they're paid a predetermined and fixed salary. They have to be paid at least a certain salary level, and right now that level is $35,000 a year, and it's about $684 a week. And then finally, employees have to perform certain duties. They have to perform primarily executive, administrative, or professional duties. Now, remember, job titles are not determinative. And exempt or non-exempt status of any particular employees must be determined on a factual basis, a case-by-case basis. And it really depends on the duties that they're doing in their jobs and whether those meet the specific requirements and the regulations. Now, a particular category of employees, whatever the title might be, may be exempt under some circumstances, but non-exempt under other circumstances. Now, the job duties test can be very tricky, and one such exception that is frequently a problem for employers, and one that we're going to dive into a little deeper this morning, is the administrative exception. Here is the definition of the administrative exception. I've gone ahead and underlined the pivotal and most crucial language in what we're going to discuss, and really the problem areas when you're applying the exception. Now, the 2 problem areas, you really need to focus on determining, 1, whether the employee is engaged in administrative work. Now, that is work directly related to management policies or general business operations of the company or the customer's business. And the second problem area is determining whether an employee exercises sufficient discretion and independent judgment. Taking the first one first, one helpful way to think of or understand the administrative work requirement is distinguish it from production or sales work. Administrative work, again, is directly related to the management of the company, management policies, and general business operations, and it is distinct from sales and production. But oftentimes there's a bit of gray area in that, in how you view certain positions. Now, as for the exercise of discretion and independent judgment, the regulations say that it involves comparison and evaluation of a possible courses of conduct in acting and making a decision after the various possibilities have been considered. It implies that the person has the authority or power to make an independent choice, safe from immediate direction or supervision, and this is important, with respect to matters of significance. It has to be a matter of significance. This is not someone who is simply applying a use of skill in various respects. It's an employee who is exercising indiscretion within the meaning of the regulations. It has to be a matter of significance, something of importance. This is not just a unimportant or relatively unimportant matter, something of some consequence. And I'll give you an example. So I read a recent case where an auditor was considered to fall within the administrative exception. And even though the auditor followed a particular set of protocols when conducting her audit, she determined the documents that would be reviewed, she determined individuals that would be interviewed, and really the general course and direction of the audit itself. And so although she was working within a set of guidelines, she had a certain amount of very significant discretion in how that audit would proceed. And so ultimately the court found that the employee had the amount of discretion that would suffice to fit underneath the administrative exception. And it's interesting to note, and something that's important to understand, is that even though that auditor, her decisions and recommendations within the audit or at the conclusion of the audit were eventually reviewed by a superior, even if your decisions are or recommendations are reviewed at a higher level, that doesn't necessarily rule you out of the administrative exception, so long as you are operating and have the power to make independent choices with respect to how you proceed with those matters of significance. And in that case, it was the sequence and the application of the audit itself. Now, let's contrast this with another case that recently came up where the court analyzed whether the exception applied to an employee of a computer programming company. And this was a computer programming trainer who went to the customer's business and was training them on the new product, the new software that they had just purchased. Now, she was teaching them how to use the program that they'd already paid for. And ultimately, she wasn't advising the customers on what software they should use or how to administer their software or what was best for their business as far as their time and attendance policies. She was strictly educating them on how to use it, training them on how to use it. And the court looked at that and said, well, that job doesn't fall within the administrative exception because that individual really is providing a service that is part of the product being produced for the customer and really not advising them on the administration of their business. So you can see how there is some distinction there, but it can get a little fuzzy when you start to talk about service employees and going into customers' facilities. So make sure that you understand that and audit your employees that might be on the fringe when it comes under the administrative exception. Another problem area is violating the salary basis rule. Employees, to meet this test, employees must be paid a predetermined fixed amount each work week without regard to the quality or the quantity of the work that they're doing in that week. Now, there are some exceptions there, and they're all listed below, but keep in mind in the context of COVID-19, employers may require employees to use available accrued paid leave to make up for time off work in the case of an office closure or in the case of a furlough due to COVID-19, so long as the exempt employee receives his or her full guaranteed pay, a guaranteed weekly salary. Really, the important part is that if they're doing work, they should be paid their entire weekly salary unless one of these exceptions applies. But keep in mind, if an employee is no available paid leave, and the employee must be paid the entire salary of for any week in which he performs any work, or else risking the loss of that exempt status. Another problem area for employers is allowing off-the-clock work, and this has been a particularly difficult area for employers during the COVID-19 pandemic. Non-exempt employees must be paid for all hours worked. If the employees spend time outside of work on activities that are considered integral to the principal activities of their job, then they need to be paid for that work. And this is where it becomes difficult, especially with employees who are working from home and are available at all times of day with these remote working setups. And so given how many employees are staying at home and working, it's important that employers understand that they're accessible 24 hours a day, and employers need to be careful to keep track of and keep tabs on non-exempt employees and pay them for the work that's being performed, or put restrictions on them so that they're not able to do that work outside of permissible circumstances. The fourth and last common mistake that we'll discuss this morning is miscalculating of regular rate of pay. Now, the pay that will be, this is essentially the pay that will employees are owed for whenever they are working overtime. What is the time and a half that they're owed if they're working over 40 hours in a work week? Now, an employee's regular rate of pay will include hourly wages, salaries, non-discretionary bonuses, shift differentials, on-call pay, commissions. It doesn't include paid leave, holiday pay, or discretionary bonuses. And you're probably wondering what's a discretionary bonus versus a non-discretionary bonus. Discretionary bonuses are sums paid in recognition of services performed during a given period, and they must meet certain specific criteria. The fact that payment will be made and the amount of the bonus that's going to be paid has to be at the sole discretion of the employer. In other words, if you're going to get it, it's up to me how much it is and when it is. And it's not based upon, the payment's not based upon any prior contract or agreement or promise that would cause an employee to expect the payment. So more often than not, these bonuses are going to be non-discretionary. Non-discretionary bonus is if there's some sort of promise, some sort of written agreement. An example, and this is from the regulations directly, would be any type of bonus that would encourage an employee to work more rapidly or efficiently. A bonus that would induce employees to stay on the job, or attendance bonuses, for instance. Those are the type of non-discretionary bonuses that do need to be included in the regular rate of pay, or when calculating the regular rate of pay. Next, we'll move on to the rules for tipped employees. And I understand that many employers and some on this call may not have tipped employees, but there have been some changes to the rules and some clarifications. So we wanted to bring those to your attention. Now, the Department of Labor has rules, and the FLSA generally requires employers to pay minimum wage, but there's slightly different rules for tipped employees. A tipped employee is defined as an employee engaged in an occupation where he customarily receives more than $30 a month in tips. Now, employers of tipped employees may satisfy at least part of the required minimum wage payment, up to $5.12 an hour, through tip credit. In other words, if an employee is tipped, they can go ahead and use that money or apply that to what they would normally pay them otherwise. Recently, the Department of Labor has made some clarifications really in the law, and they've declared that tipped employees, really their work is split into three categories. It's going to be tip producing work, work directly supporting tipped work, and work that is not part of a tipped occupation. Now, tip credit, and the rules have really defined and have specifically addressed, tip credit may only be taken for workers spent on duties or work that's spent on duties that produces tips or that are directly related to work that produces tips. Now, under the final rule that's come out recently, and these rules have been, over the last year or so, they've been developed sporadically and come out. But now I think we have finally got the set of regulations as they're going to be for the foreseeable future after the change of administration. But under the final rule, any time spent in the third category, so work that is not directed towards a tipped earning or tipped earning work, must be compensated, and full minimum wage, even if it's only 5 minutes of non-tipped work, needs to be paid. The DOL also revived what is known as the 80-20 rule for tipped workers. The so-called 80-20 rule was first adopted back in the 80s, and then the Obama administration really expanded the types of tasks that were deemed not tip work. And then eventually the Trump administration attempted to remove the rule entirely, and now it's been brought back to life by the new administration. But here's what you need to know. Time spent directly supporting duties, so in those first two categories, or that second category, may be paid a tip credit rate, but only if the work is either one, more than 30 continuous minutes, or two, more than 20% of the hours in a work week for which the employee has taken a tip credit. So those are kind of those are the bounds of when an employee can receive credit towards that second category. Another clarification on the rules is that regardless of whether they get tip credit, employers cannot keep tips received by employees. They absolutely cannot. Employees' tips are their own, and that includes managers and supervisors. They cannot take employees' tip money. The only time a manager or a supervisor could earn a tip and keep a tip is if they receive the tip themselves for the work that they do, and it is work that is directly related to earning a tip. And there's an example there of a salon manager who can keep tips if she's working on those customers who she personally styles without violating the statute. And finally, the last clarification that we received under the new tip rules is under the new rule, employers can face fines of $1,100 each time the department finds that an employer unlawfully retained an employee's tips. Before they had loosened this a little bit and had made it, they wanted to make it clear for employees it doesn't matter. It's regardless of whether it's repeated or willful, it's going to be $1,100 each violation. And with that, I'm going to tell everyone our first secret word of the day as I conclude. And the first secret word is Fox. So if you'd please select the correct word from the selections on your screen. And then I will turn it over to Krissa Lubben. Thank you.
Good morning. My name is Krissa Lubben, and I'm happy to talk to you today. I know all of you are very anxious. Looks like we've got the screen back to make sure everybody has done that. That secret word is Fox, if you didn't get that. Happy to talk to you today. I know all of you are very anxious to get to the vaccine mandate information, but there have been a couple of other things that have been going on besides COVID, and one of those is the new statute that was enacted by Missouri called the Victims Economic Safety and Security Act, VESSA. And I wanted to talk just a little bit about that. So it was effective in August of this year, and as of October 27, 2021, employers were required to provide notice to their employees about this law here in Missouri. And there's a continuing obligation to make sure you tell new hires about this law when they become hired. Now, this applies to any Missouri employer who has at least 20 employees. And you have to provide 1 week of unpaid leave if you have under 50 employees. If you have more than 50 employees, it's going to be 2 weeks of unpaid leave. Now, what kind of leave do you have to provide? Well, you have to provide leave for circumstances that relate to domestic or sexual violence. And the reasons that you have to provide those leave are fivefold. First, it's to seek medical attention for the employee, his family member, or someone in their household, or it's obtaining victim services. The other reason is if they need to have psychological counseling or other counseling, and safety planning and participation. What does that mean? It may mean things like helping them to, give them time off so they can relocate, even on a permanent or a temporary basis. And then legal assistance and proceedings. So you need to provide leave to your employees if they have to, provide statements, go to the police, find a lawyer, participate in hearings, or attend trials, or go and get a order of protection. So this leave can be taken on an intermittent or reduced level, reduced basis, similar to the FMLA, the Family and Medical Leave Act. You can, as an employer, require certification, and you can require 48 hours notice before you grant this leave, unless that wouldn't be practical, and then you need to provide them the leave. And together, if the employee is eligible for family and medical leave, the leave together cannot exceed 12 weeks in a given year. And under Missouri's VESSA, there can be no retaliation for an employee who takes this leave for themselves, their family member, or for someone in their household. You also have to reinstate that employee to the same or a substantially similar position upon the conclusion of their leave, and you have to make reasonable safety accommodations. Well, what are reasonable safety accommodations? Well, that could include a transfer, a reassignment, changing their work phone number or their seat assignment, securing a lock, putting a lock in the workplace, perhaps coming up with a safety plan, and things such as that to help somebody who's dealing with these issues. So how does this differ from Illinois' VESSA? For those of you who have employees both in Missouri and Illinois, they differ a little bit. Missouri's law was enacted this year in 2001, but Illinois has had their VESSA law since 2003. but it's changed some. In Missouri, it applies if there's 20 employees. VESSA in Illinois, when it was first enacted in 2003, required an employer to have 50 employees. That has changed. In 2009, it changed to 15 employees. It was you had to provide this type of leave. And in 2017, it now applies to anyone in Illinois who has one employee. The amount of leave in Illinois is also different than Missouri, and it depends on the number of employees. But at a minimum, if you have one employee in Illinois, you're going to have to provide 4 unpaid weeks for this leave and up to 12 weeks of unpaid leave. The other distinction between the two is in Missouri, it's domestic or sexual violence. In 2020, Illinois changed their law to also include gender violence. The laws are similar, though, in the sense that they have the same qualifying reasons, the same definition of family member, and they both require that reasonable accommodation. However, in Illinois, it's going to change even more effective January 1, 2022. In addition to leave for domestic, sexual, gender violence, it also will include the need to provide leave when there is any other crime of violence. And what does that mean? Well, it's anything that would be in the criminal statutes in Illinois. So that broadly expands what you will have to provide leave for. In addition, it changed the definition of who is a family member, and it will include grandparents, siblings, grandchildren, and anyone else who lives in the household that really is the equivalent of a family member. So much broader in that sense. In addition, it also requires what kind of documentation you can get. For example, if the employee doesn't have in their possession documentation to support the leave, you still have to grant the leave if they don't have it. In addition, it also sets forth what you can ask an employee to provide. And if the employee gives you a certain documentation, you can't ask for more unless and under very limited circumstances can you ask for more than what the employee provides. In addition, it requires confidentiality, and it also expands the anti-discrimination portion of Illinois' VESSA to include job applicants and employees who are perceived to be discriminated against based on their need for domestic, sexual, gender, or this other crimes of violence. So what this means is if you have employees in Illinois and you have not looked at your VESSA policy since 2003, you need to dig it back out and look at it because it has changed significantly. What about other states? If you have employees in other states besides Illinois and Missouri, you need to look at those. There are about 34 states that have some type of requirement to provide leave when there is an issue of violence. However, they vary greatly. They can depend on the number, it'll change. They vary on the number of employees you have to have in that state, what is violence and how it's defined. It also varies on who is a family member. And some of the states don't actually have, like Illinois and Missouri, a VESSA, something that deals only with this issue, but rather it's embedded in their mandatory sick leave law or their paid time off law. So you need to dig a little bit to find out, do you have to provide leave when there are these situations involving violence? And then there are some states that don't have anything, but in that state, a city or a county has actually enacted some kind of protections or requirements that you provide leave under these circumstances. So what do you do now? Well, you have to determine what states apply and what laws apply for your workforce if you have employees in many states. You also have to determine what notice and posting obligations you have under these various laws, and you need to review the policies, and if you don't have those policies, draft those policies. And especially with Illinois, if you haven't looked at it since it got enacted in 2003. And then finally, I encourage all of you to train your supervisors so that they recognize that there is this leave out there and recognize that when employees come to them or they hear things that would allow an employee to take leave under these circumstances. And with that, I will on to our second secret word. Our second secret word is brown. Again, our second secret word is brown. Please select that on the drop-down menu. All right. And again, it was Brown. And with that, I will turn it over to Susan, who's going to talk about some changes, some additional changes in Illinois law.
Thank you, Krissa. And as Krissa mentioned, we know everyone's eager to hear about the new changes and implementation issues around the OSHA rule. So we will be moving through these relatively quickly. I encourage anyone who has Illinois employees to reach out with any issues, and I'm happy to touch on those. The first topic we're going to talk about are restrictions and obligations on the employer's use of criminal background checks in Illinois. Anyone who has dealt with Title VII and its rules around utilizing background checks, especially criminal convictions, will find a lot of familiarity in this. In many respects, the amendments are codifying what we've already been dealing with on the federal aspect. But that being said, these amendments went into effect this past March. It now specifically includes protection of conviction records. Recall that the Illinois Human Rights Act already prevented us from relying on arrest records when making employment decisions. And so this is codifying those issues around conviction records. Penalties for these violations by an employer includes uncapped compensatory damages, back pay, front pay, reinstatement, attorney's fees and costs, and punitive damages. So hopefully it becomes evident very quickly that these have tangible effects if violated. The amendments make clear that employers are only permitted to use conviction records as the basis for an employment decision if they can show a substantial relationship between one or more of the previous criminal offenses and the employment sought or held, or conversely, if the granting or continuation of employment would involve an unreasonable risk to property or to the safety or welfare of specific individuals or the general public. Again, this is largely codifying what we already knew to be in effect for Title VII, but we are expounding upon it because the amendments go on to say that in order to determine if one of these exemptions applies, the employer must consider whether there is an opportunity for the same or similar offense to occur, and, not or, and whether the circumstances leading to the conduct for which the person was convicted will recur in the employment position. Again, this all kind of harkens back to that job relatedness aspect of it, meaning do they have a likelihood that they will engage in the same conduct because of the position you are potentially putting them in. Consistent with, to a large degree, with the Title VII guidelines, the Illinois list is now a codified statutory requirement of things to take into account when making these kind of determinations. And like the Title VII assessment, the Illinois analysis requires a case-by-case interactive assessment, during which we will take into account these delineated factors. How long ago the conviction took place, the number of convictions, the nature and severity of the conviction and its relationship to the safety and security of others, the facts and circumstances surrounding the conviction, the age of the person at the time of the conviction, and whether there is any evidence of rehabilitation efforts. The amendments go on to say that in order to rely on the conviction, certain steps must take place. And these are steps that are more aligned and consistent with what the Fair Credit Reporting Act had already required in the event that an employer wanted to rely upon a past conviction record. But it again, to stay consistent, codifies those rules from a state perspective and specifies the amount of time required to provide some of these notifications. So first, the employer must notify the individual of its preliminary decision in writing, specifying which conviction was the basis for the decision and notifying the individual of their right to respond. This is akin to the Fair Credit Reporting Act's pre-adverse action letter. This must be accompanied, however, by a copy of the conviction record. That is a departure from FCRA. A further departure is that the Illinois amendment makes clear that the individual then has 5 business days to respond. There is no day delineated in FCRA. If the individual does respond, the employer is required to consider the information submitted before making a final decision. the notification should also indicate that they can provide proof of rehabilitation and any other facts that they think is relevant to discredit the conviction itself. If we then conclude that the individual is in fact disqualified, the employer must again provide written notice to the individual stating which conviction was the basis of the decision and any procedure the employer has to challenge the decision or request consideration, as well as the individual's right to file a charge with the Illinois Department of Rights. So in many respects, this is a combination of the pre and post adverse action letter, but it takes it a step further to say that we have to provide them notice that they can file a charge with the IDHR. Our next topic will include upcoming changes to non-solicitation and non-competition provisions. This is known as the Illinois Freedom to Work Act. It goes into effect on January 1st, so anyone who is in the process of looking at their employment agreements or separation agreements, you have a good amount of time to still do that. That's even more important because the requirements under this law are not retroactive. So while you can still use the agreements that you have in place up until January 1 and not face any repercussions under this new law, we do have to be prepared as of January 1 to have our new agreements in place. The remedies for a violation of this act include a fee shifting provision, but only for the prevailing employee. That is to say that if we sue the employee for violating their non-compete after we've revised the agreements as of January 1 and we win, we as the employer do not have the right to go after the employee for our fees. Conversely, if we either lose or if the employee sues us for violating the Illinois Freedom to Work Act because our agreement is non-compliant, they would be entitled to their fees. So there are a couple of components of the Illinois Freedom to Work Act, the first of which is their monetary requirements. And this is a marked departure, so I encourage everyone to pay close attention to this if you have Illinois employees who are subject to non-competes or non-solicits. Employers cannot enter into enforceable non-compete agreements with Illinois employees who have expected earnings of less than $75,000. Now, in the interest of time, I'm not going to go over all of what expected earnings means, but suffice it to say it is a very broad definition and includes deferred compensation and bonuses that are potentially discretionary and whatnot. So if you have an employee who is hovering around this $75,000 mark, we should be very careful when we scrutinize whether we feel as though they are going to hit that expected earnings threshold. This is a threshold that goes up over the next several years, and you see on the screen the breakdown for that increase. Similarly, we cannot enter into non-solicitation agreements of either employees or customers for those who have expected earnings of less than $45,000. And again, that number goes up over subsequent years. So the bottom line is if you have an employee who makes less than $45,000 as of January 1, we cannot enter into non-solicits or non-competition agreements with them and expect that the agreement will be enforceable. Subsequently, conversely, if someone is making in excess of $75,000, we at least know that we will meet this monetary component threshold. And then we need to turn to the reasonableness component. This law, in many respects, codifies what case law had already told us, that non-competition and non-solicitation agreements have to satisfy the employer's legitimate business interests. This requirement, much like the courts, look at the totality of the circumstances, such as time, place, and scope of activities, and the employee's exposure to the employer's near permanent customer relationships. Again, this is not much of a change from what we already knew when looking at the way Illinois courts had analyzed restricted covenants. But the third component, which is in my assessment, the most important component is not just a review of case law, but a codification of a concept that had been floating around in Illinois case law for the last couple of years, which is to say we now have to ensure that we have adequate consideration as defined by the Illinois Freedom to Work Act. That means that either the employee worked for the employer for at least 2 years after the employee signed an agreement containing the restrictive covenant, or the employer otherwise provided consideration adequate to support the agreement. Now, that can either be financial benefits plus professional benefits or just financial benefits alone. There was a case called FEFOLD several years back that the Illinois Supreme Court declined to take up, which found that a non-compete was non-enforceable because the individual did not work there for at least 2 years after they signed it. And there's been a lot of questions and conversations amongst other courts as to whether FEFOLD is good law. Now the Illinois Freedom to Work Act has taken that issue off the table and has specified exactly what FEFOLD stated. So my guidance to a lot of employers is that if you are at all concerned about the longevity of the employee and the desire to be able to enforce the non-compete, I encourage some sort of a signing bonus that is solely for the purposes of the non-competition or non-solicitation agreement. And this new law reinforces that. Your question is going to be, what is a reasonable signing bonus? And unfortunately, we do not have any guidance from the legislature around what that might be. So my advice has been that it needs to be something more than a de minimis amount. And I think it needs to be tied to what the compensation of the individual is. If someone is making, $76,000, maybe a $1,500 signing bonus, maybe a $500 signing bonus is reasonable consideration. If someone's making $500,000, I doubt that a $500 signing bonus would be deemed sufficient consideration. This is an area where I hope that we'll get more guidance from the courts as this law is scrutinized in the future, and we will certainly keep everyone up to date on those developments. And then finally, some of the technicalities around this law. We have to provide employees 14 days to review the restrictive covenant before they are forced to sign it. We also have to give them the opportunity and direct them to speak to an attorney before they sign it. The good news is that we are now able to rely upon judicial reformation. This is the blue penciling concept that a lot of you have heard of, whereas before there was some inconsistency in Illinois. Now there's something for judges to hang their hats on to feel comfortable modifying our restrictive covenants if they feel like it might be a tad overly broad. Although if we are violating the salary threshold, we should not be expecting the judicial reformation to kick in because it will just be void as a matter of law. To that point, the covenant not to compete is void and illegal if entered into with someone who has a collective bargaining agreement or is subject to the Illinois Educational Labor Relations Act, as well as individuals employed in construction. So if you have employees in the construction industry, let's talk about what that means. If you have someone who is an officer in that industry, it's quite possible that we would still be able to enforce a non-compete. But if someone is more of a laborer, we're going to have harder time enforcing a non-compete. And also, and hopefully this is an aspect of the law that will not be relevant for much longer, but if someone was laid off or terminated as a result of COVID, a non-compete cannot be entered into or relied upon. And finally, changes to the Illinois Equal Pay Act. This is a pretty meaty act. So if you have employees in Illinois in excess of 100, we should plan on talking, or you should reach out to either your accountant or your attorney to get into more of the nuts and bolts of this. It is also a bit of an evolving amendment because we have yet to see how this is really going to play out with the Illinois Department of Labor. It did technically go into effect in June, but the certifications that you're going to hear me talk about in a second will not even be mailed out until March. So we truly don't know how this is going to work practically speaking yet. But be that as it may, the amendments do make clear that it applies to anyone with more than 100 employees in Illinois, not 100 employees nationwide like the EEOC's EEO1 reporting requirements, but specifically 100 employees in Illinois. And it will require covered businesses to recertify every 2 years. And that 2-year period will start based on when the initial certification is sent out, which could be anytime between March of 2022 and March of 2024. In order for a covered employer to apply for the certification, the employer has to first pay a $150 filing fee and submit wage records and an equal pay compliance standard to the Illinois Director of Labor. The wage records themselves must include a list of all employees from the prior calendar year, separated by the protected categories that are already delineated by the EEO1 report. But in addition to the type of information required in that EEO1 report, the wage record has to include the county where each employee works, the date the employee started working for that business, and the total wages paid to each employee during the past calendar year, rounded to the nearest 100. Again, more information than the EEO1 report requires. So if you are a covered employee, I recommend that you start pulling this information together now, since theoretically, at least, you could be receiving a certification as early as the upcoming March. Then, in addition to the wage record, we have to provide a compliance statement, which must be signed by a corporate officer, legal counsel, or authorized agent of the business, and states via that certification that the business is in compliance with the Equal Pay Act and other relevant laws. Now, there is some definition within the Act of what other relevant laws means. It specifies Title VII, the Illinois Human Rights Act, but also has a nice catch-all of and any other relevant laws. So that is a somewhat of a daunting certification to make, and one that should not be taken lightly. The certification also needs to say that the average compensation for its female and minority employees is not below the average compensation for its male and non-minority employees. I believe that that will be based on specific job classifications or titles, such that it won't be looked at from an entire company-wide perspective. We are awaiting to see what those certifications look like, but we should be prepared to do the analysis now to see if that type of a statement can in fact be made and attested to by a corporate officer. And finally, the certification needs to say that the business does not restrict employees of one sex to certain job classifications. Once those two prongs have been provided, the wage records and the certification, if the Illinois Department of Labor rejects those applications because of missing information, incorrect information, what have you, we have 30 days to cure those deficiencies. So we do have some opportunity before we then are subject to the fines of $10,000 per employee affected that the Illinois Department of Labor could level against the employer. And with that, I bring us to our third question with today's secret word. Today's secret word is car. Please select the correct secret word from the selections below before I turn it over to our team of OSHA experts who will be talking about the new mandatory vaccine law. And with that, I will turn it over to John Viola and the rest of the team to talk about the new OSHA rules.
Thanks, Susan, and good morning, everyone, and welcome to what's turning out to be a continuing series of Thomson-Coburn webinars on employers' responses to the pandemic. As you all know by now, on Friday, November 5th, just 4 days ago, published its emergency temporary standards, the ETS, pursuant to President Biden's Path Out of the Pandemic plan that was announced just a month or so ago. This morning, I'll provide a general overview of the ETS for large employers. Colin will talk about the logistics of creating and implementing an ETS compliant program. David will speak about requirements for employers in the healthcare area. And last but not least, Dave and Amy will answer any questions you may have or that have come up to us already in the only 4 days since the regulations were announced. Now, it should come as no surprise to you to find that the ETS already has been challenged in court. Just this Saturday, a day after the ETS were published in the Federal Register, the Fifth Circuit entered a temporary stay, staying the ETS. As of yesterday, 12 lawsuits challenging the ETS have already been filed in the 5th, 6th, 7th, 8th, 11th, and D.C. Circuit Courts of Appeal. The Department of Labor and OSHA have already notified the Judicial Panel of Multi-District Litigation of these challenges, and the panel is expected to hold a hearing on November the 16th to assign the cases as consolidated before one of those circuit courts of appeal. And after that is decided, we can, I think, with a lot of confidence, expect that the challenge to the ETS will reach the U.S. Supreme Court. Now, as we'll see on the next slide, because the first compliance deadline for the ETS is December 5th, the initial stay will not affect implementation unless it's extended past that date. And so for now, with everything up in the air, we're recommending that employers prepare for the ETS as being effective on December 5th until a final decision has been made. But before we get into the specifics of the ETS, for those of you who have been following the news of the President's plan, or if you attended our webinar back on what seems years ago now in the COVID area, October 13th, you'll note that it's not all that much changed in the last month or so. There are some very specific requirements imposed by the ETS, so let's get right to it. The ETS provides that employers must be in compliance with all requirements of the ETS except for the testing requirements by December 5th, 2021. If you choose to allow employees to opt out of vaccinations by agreeing to be tested for COVID-19 weekly and to wear a face mask covering while indoors, you must be in compliance with the testing provisions by January 4th, 2022. And because it's only an emergency rule, the ETS is set to expire 6 months from its publication date, or on May the 5th, 2022. Now, who does the ETS apply to with respect to private employers? The ETS mandates vaccinations or, in the alternative, at least weekly testing plus wearing a mask for employees of large employers. Who's a large employer? Large employers are those employers with 100 or more employees on a firm-wide or a company-wide basis, rather than a location-by-location basis. As an example, if you have 100 or more employees in one location, you're covered. If you have only one employee in 100 locations, you're also covered, and obviously any permutation in between. And who do you count for accounting purposes to reach this 100 employee threshold? Well, to determine whether or not you're covered by the ETS, you must count all of your employees, including both part-time employees and employees who work remotely or at off-site locations. Employers are not required to count independent contractors or temporary workers which are employed through a staffing agency. Those staffing agency employees are counted towards the staffing agency's number of employees, not at the business at which they are working. Not all employers and employees are covered by the ETS. The ETS doesn't apply to workplaces covered either by the Safer Federal Workforce Task Force guidance for federal contractor or by OSHA's July 2021 ETS regarding COVID-19 safety precautions for healthcare facilities. We spoke about the contractor and healthcare facility requirements last month, and Dave is going to give us an update on the healthcare facilities later in this program. It's important to note, however, that because these exceptions apply at a workplace level, a company might have some of its facilities covered by the federal contractor guidance, some of its facilities covered by the healthcare rules, and still others covered by the ETS for large employers. Or, of course, all three requirements may apply in some workplaces. Now, while they must be counted towards the 100 employee threshold, the requirements of the ETS regarding vaccines or mask wearing don't apply to those employees who don't report to a workplace where other individuals, such as coworkers or customers, are present, while an employee is working from home, or to those who work exclusively outdoors, in other words, never coming indoors. So we've been talking about vaccination or testing. What does the ETS provide? Well, it requires large employers to either, one, establish, implement, and enforce a written mandatory vaccination policy, or two, establish, implement, and enforce a written policy allowing any employee who's not subject to a mandatory vaccination policy to choose either to be fully vaccinated against COVID-19 or to provide proof of regular testing for COVID-19 and to wear a face covering, except in limited circumstances. The ETS also allows a single employer to maintain both policies for different groups of employees. So, for example, you can enforce a mandatory vaccination policy for customer-facing employees, but you might choose to allow administrative staff who are not customer-facing to choose the testing and masking option. It's up to you. So let's talk first about the first option, the mandatory written vaccination policy option. To comply with the ETS, a mandatory vaccination policy must require that all employees, all of them, be fully vaccinated for COVID-19, other than for employees for whom a vaccine is medically contraindicated. For instance, they may be allergic to the vaccine, as certain quarterbacks claim, for whom medical necessity requires a delay in vaccination, or three, the third exception is for those employees who are legally entitled to a reasonable accommodation because they have a disability or because they have sincerely held religious beliefs, practices, or observances which conflict with the vaccination requirement. OSHA has already taken the position that employers who have adopted a mandatory vaccination policy are not required to continue to employ an unvaccinated person who refuses to get vaccinated. Now, this, of course, is subject to accommodation for disability and religion. Option two is for the vaccination or testing plus wearing a mask policy. Under option two, if an employer chooses not to adopt the mandatory vaccination policy, the employer must give its employees the option either to, one, become fully vaccinated, or two, to submit to weekly testing for COVID-19 and to wear a face covering while indoors or when occupying a vehicle with another person. With respect to testing, employees who report to the workplace at least once every 7 days must be tested at least once every 7 days and must provide documentation of the test results to the employer no later than the 7th day following the date on which the employee was tested. Employees who report to the workplace less than every 7 days must be tested within 7 days prior to returning to the workplace and must provide the test result upon returning to the workplace. If someone refuses or fails to provide test results, the employer must, this is a requirement, the employer must exclude the employee from the workplace until the employee provides the test result. Now, only tests that have been authorized by the FDA may be used to meet the testing requirement. This includes the laboratory-based NAAT tests and rapid antigen tests. Now, you might ask, can an employee use self-administered tests? Yes, they can be both self-administered and self-read, but the self-administered testing must be observed by either the employer or an authorized telehealth proctor. This means that any employee using an at-home test must be observed by a telehealth provider or by the employer in order for the result to be considered valid under the ETS. Antibody tests, in other words, a test that shows whether someone's been infected with COVID-19, are not acceptable under any circumstances. Now, assuming that you're going with option 2, the testing plus masking policy, any employee who is not fully vaccinated must wear either indoors or while occupying a vehicle with another person, except when that person is alone in a room with both floor-to-ceiling walls and a closed door for a limited time while the employee is eating or drinking at the workplace or for identification purposes, or where the employer can show that the use of a face covering is infeasible or creates a greater hazard that would excuse compliance. Employers must ensure that face coverings are worn to fully cover the employee's nose and mouth, and that they are replaced when they are wet, soiled, or damaged. Employers are not required under the ETS to pay for any costs associated with face coverings unless otherwise required by state or local laws or collective bargaining agreements. In order to encourage vaccinations, the OSHA ETS states explicitly that employers are not required to cover the cost of testing or to provide face coverings. Finally, employers are prohibited from preventing any employee from voluntarily wearing a face covering or face mask unless the employer can demonstrate that doing so will create a hazard of serious injury or death. What if you have a location in one of the 28 states and territories, such as California, which have its own OSHA-approved state plan? These states and territories will have 15 days after the publication of the ETS, so in other words, by November the 19th, to adopt the ETS for their states or announce, quote, at least as protective, unquote, alternative plans. For those states that have received final OSHA approval, the only mechanism for OSHA to enforce the ETS in those states would be to withdraw plan approval, either in whole or in part. A partial removal would likely take at least 6 months, and a full removal would take as much as a year. So stay tuned on this issue if you're in one of the OSHA, the mini OSHA states, as we call them. The ETS also preempts state and local governments from adopting and enforcing workplace requirements relating to occupational safety and health issues of vaccination, wearing face masks, and testing for COVID-19, except under the authority of a federally approved state plan. Specifically, OSHA intends for the ETS to preempt and to invalidate any state or local requirements that ban or limit an employer's authority to require vaccination, face covering, or testing. The reasoning behind this is that state and local requirements that prohibit employers from implementing employee vaccination mandates or from requiring face coverings in workplaces serve as a barrier to OSHA's implementation of the ETS and the protection of America's workforce from COVID-19. Note, however, that the ETS does not preempt state and local requirements regarding vaccine or masks wearing in public spaces, such as been adopted in Los Angeles and some other localities. And last but not least, the ETS establishes minimum requirements for employers. Nothing in the ETS prevents an employer from agreeing with their employees or deciding on their own to implement additional, more stringent measures. And of course, the ETS does not displace collectively bargained agreements. And now I'm going to turn it over to Colin. We'll talk a bit about logistics of complying with the ETS.
Thanks, John. So now we're going to talk about what putting together a compliant policy and plan looks like. We're going to focus on what you need to start doing right away to meet the December 5th deadline that John talked about. Now, as we've talked about in recent webinars, your first step should be to figure out the vaccination rate among your employees. And the best way to do that is with a simple 2-question survey. Are you fully vaccinated, and do you intend to become fully vaccinated? Remember, at the survey stage, you're not asking people why they do not intend to be vaccinated. If you decide to go the testing route, that information isn't necessary, and it could be considered a disability-related inquiry under the ADA. Now, once you have your survey data, you'll need to pick a plan, either the mandatory vaccination plan or the option between being vaccinated or being tested and required to wear a face covering. Keep in mind that OSHA hasn't been shy about the fact that they have a heavy preference toward mandatory vaccination policies. And likely because of that, they've heaped a lot of administrative burdens on the testing program. So if you have a really high vaccination rate in your workplace, the mandatory vaccination policy might be a better option for you to cut back on those administrative costs of implementing a testing policy. On the other hand, if you have a low vaccination rate and a large percentage of your employees said they do not intend to become vaccinated, you'll most likely prefer the policy with the testing option. Now, once you've chosen your option, the next step is to draft a written policy. The ETS requires employers to maintain a written vaccination policy, and it includes a large number of required items. Essentially, the written policy has to set out all of the processes, all of the procedures, how you're going to collect information, how you're going to determine who has been vaccinated, and who has to be tested. Now, the rest of my slides are going to go into more detail on exactly what needs to go into the policy and what choices you have for those different aspects. Once you have the policy, then you need to distribute it as well as a number of notices to your employees. While you only need to distribute the information once, if you go back and modify any part of your written policy, you're going to need to redistribute it. Okay, policy requirements. We're going to talk about what actually has to go into the written policy. The items on this slide are not everything that needs to be included, but they are some of the bigger items. I also want to note that if you've previously implemented some form of vaccination or testing policy, it's unlikely that it included everything OSHA says this policy needs to have. So now would be a good time to go over your current policy and see which gaps you need to fill in order to become compliant by December 5th. All right, so the most important part of your written policy is the part that tells your employees which vaccination policy you've chosen to go with and what they need to do to comply with it. For example, if you've chosen a mandatory vaccination policy, you need to tell the employees how to request an accommodation and what are the consequences for not being vaccinated by the deadline. If you've chosen the vaccinate or test policy, you need to tell employees things like which tests they can use, where they can get vaccinated, how to report test results, and in which circumstances they have to wear a face covering. Next are the effective dates and deadlines. For your employees, the big deadline is January 4th. That's the date where employees either have to be fully vaccinated and have turned in proof of vaccination, or have to begin weekly testing and wearing face coverings. Depending on your state, you can choose to move that deadline forward. However, keep in mind the time that it takes to become fully vaccinated. You know, for the Johnson & Johnson vaccine, a person can become fully vaccinated in 2 weeks. But if we're talking about the Moderna vaccine, then it's closer to 6 weeks. And that means someone taking the Moderna vaccine has to have had their first shot by no later than November 23rd in order to be fully vaccinated by January 4th. Who the policy applies to will be the section where you can say that, employees who work remotely do not have to be vaccinated or test, as long as they're not coming into the office. And the procedure for new employees will likely be to give new employees the opportunity to turn in vaccination documentation with onboarding materials, or else agree during that process to undergo weekly testing. And the next few slides, we're going to go into a bit more detail on the remaining items I have here. All right, so one of the biggest administrative hoops of the ETS is collecting, maintaining, and protecting information related to vaccinations and testing. First, let's talk about vaccine records. Except for one very narrow exception, employees will have to prove their vaccination status through some sort of official documentation, which the ETS calls an acceptable proof of vaccination. These acceptable proofs include the record of immunization from a healthcare provider, a copy of the COVID-19 vaccination card, or a copy of medical records documenting the vaccination. Now, if an employee loses all of their vaccination documentation and they've attempted to get replacement information from their healthcare provider and they can't get any of it, then the employee may sign an attestation that they've been vaccinated. However, there are a lot of requirements on what goes into the attestation, including language that says the employee knows providing false information could subject them to criminal penalties. Once an employee has given you proof of vaccination, you're required to retain a copy of it for at least the life of the ETS, likely longer. The ETS says that all vaccine records must be treated as confidential medical information, which means you should keep it separate from general personnel files, and you should restrict access to vaccine records except for those people who have a business need to know. And this is what we've been advising people generally with vaccination and testing information. Finally, we need to talk about the roster. Under the ETS, you're required to maintain a roster of all of your employees, which clearly indicates for each employee whether they're fully vaccinated, if they're partially vaccinated, if they're not fully vaccinated because they've received some sort of an accommodation, or if they're not fully vaccinated because they haven't provided acceptable proof of vaccination status, which would include people who have opted into the testing program. As we'll talk about in a few slides, the roster needs to be kept up to date and in an easily accessible form because OSHA can request the roster with only 1 day's notice. And now let's talk about documentation for COVID testing. As John mentioned, employers who are not fully vaccinated must submit test results on a weekly basis. And the ETS requires employers to retain every single test result received from every single employee for at least the life of the ETS. Like vaccination records, test results should be treated as confidential medical information, and access to them should be restricted. And finally, I want to talk briefly about testing and tracking, or vaccination and testing tracking apps. A lot of companies, including payroll providers, are developing and marketing apps and programs that help you track your employees' vaccination and testing records. When evaluating if a particular app is right for you, there are 2 things you need to make sure of. First, you need to make sure that it has the proper security protocols in place to protect the information. Remember, we have to treat it as confidential medical information. Second, you should make sure that the underlying data is easy to access. As we'll discuss in a minute, OSHA and employees can request a lot of data on very short notice. This means that you need to be able to download and transmit the data quickly. So you should avoid any apps or programs that just show you the information without giving you easy access to the underlying data. Now we're going to talk through what needs to be in your policy regarding employees testing positive. And remember, these are requirements for your program, but they're also requirements for the written policy. All of your procedures need to be set out in writing in quite a bit of detail. So first, you need to have a section of your policy that requires employees to notify you promptly if they test positive for COVID. Now, if you're conducting testing at your facility for employees who have opted out of the vaccination requirement, then you'll know immediately. You'll have easy access to those test results. However, there may be times when an employee takes a non-work related test, for example, if they're about to travel. These results also need to be reported to you, the employer, if they're positive. The ETS requires employees to notify you promptly, and for practical purposes, promptly means at least before reporting to work on their next shift. And that's because you'll need to exclude employees who have tested positive from the workplace. And this needs to be in your policy, explaining that any employee who tests positive or is diagnosed with COVID-19 may not enter the workplace. And if they receive the positive test results while at work, if they send out a lab test and they get a notification during working time, they need to tell their supervisor immediately, and then they need to leave the workplace. You'll also need to include your procedures for returning to work after a positive test. Under the ETS, employees may not return to work until either the employee meets the return to work criteria in the CDC's isolation guidance, and that's the standard. It's been at least 10 days since symptoms began, at least 24 hours since you've had a fever and your other symptoms are improving, or the employee receives a recommendation to return to work from a licensed healthcare provider. Now notice that neither of these options includes returning to work after a negative COVID test. And that's likely because of what OSHA believes is a high likelihood of false positives after infection. So if you wait for a negative test, you could potentially be holding the employee out of work longer than they need to be. But there is one exception to that rule. If the employee's original positive test was from an antigen test, this is your rapid test, likely what most of your employees will be using, the employee can take a confirmative NAAT, which is considered the more accurate test. If that NAAT is negative, then the employee can return to work immediately. And usually that means that the antigen test was a false positive test. Finally, the ETS doesn't require you to take other precautions like contact tracing or excluding employees who've been exposed to someone with COVID from the workplace, but you can choose to add those to your policy if you like. Remember, the ETS gives you the minimum requirements. As John said, you're allowed to impose more stringent measures and requirements. Now, as I've mentioned briefly before, the ETS puts some fairly stringent reporting obligations on employers, and these obligations must be spelled out in your written policy, along with the procedures to request information. Essentially, this is going to be OSHA's way of partially delegating enforcement to employees. OSHA thinks that if employees have access to more information, it's more likely that they will monitor their employers and report any deficiencies to OSHA, which cuts back on the number of investigations OSHA needs to perform. So let's talk about the information that employees can request. First, they or an authorized representative can request any vaccination or testing records you've maintained on that employee, which is why it's important that you keep those records in an easy to access format. Second, they can request the total number of vaccinated employees in your workplace and the total number of employees in your workplace, which will give you your vaccination rate. When we're talking about employees reporting deficiencies to OSHA, One example would be an employee requests the aggregate number of vaccinated employees and total employees and sees that there's a low number of vaccinated employees, but they notice that most of the people working around them are not wearing face coverings. So they might report to OSHA that you are not requiring unvaccinated employees to wear face coverings, which could start an OSHA investigation. Both of the sets of information employees can request, you have to provide it to the employee within 1 business day. Now, you only need to provide 1 copy to them for free, but if any information changes, if they get new test results and they request those, then you have to give them that information again free. And then there's the information that OSHA can request. First, they can request a copy of your written policy, which you have to provide to them within 4 hours of the request. So it's very important that you have a policy that complies completely with the ETS before they request it. Second, like employees, they can ask for your total number of employees and the total number of vaccinated employees. And they can ask for anything the ETS requires you to maintain. And that could be vaccination records, it could be testing records, and it could be that roster. Any documents in those last 2 categories must be produced within 1 business day. It's only the written policy that needs to be produced within 4 hours. Now, the last policy item I want to discuss is the ETS leave requirements. Under the ETS, you're required to provide paid time for employees to receive vaccinations and to recover from any adverse reactions to the vaccine. As with everything else we've discussed, the policy and procedures for taking leave must be included in your written policy. So first, we have paid time for vaccinations. Now, under the ETS, employers are required to provide employees with up to 4 hours to receive a vaccine dose during working hours. Those hours have to be paid at the employee's regular rate, and employees cannot be required to use any accrued PTO or sick time to cover the vaccination time. Now, remember that the ETS requires you to provide that time during working hours. If you provide time during working hours and an employee chooses to get vaccinated outside of working hours, you do not need to pay them for that time. That's their choice. That's not required to be compensated. And second, we have paid leave for employees to recover from adverse reactions to a vaccine dose. Unlike time for vaccinations, employers may require employees to use accrued PTO or sick time if available. And available here means accrued. So you can't require employees to borrow against future PTO. Now, if the employee does not have any PTO or sick time stocked up, the employer must provide paid leave for a, quote, reasonable time. Now, the ETS itself doesn't give us a hint as to what a reasonable time might mean, but thankfully OSHA decided to tell us in one sentence of the 450-page preamble to the ETS that it will consider paid leave of at least 2 days to be reasonable. So if you provide paid leave of 2 days for employees who have severe reactions to the vaccine, that's reasonable. Finally, I'd like to note that none of this leave is retroactive. So any vaccination or recovery time an employee needs before December 5th would not be covered by the ETS. It may be covered by a local law, a collective bargaining agreement, or one of your employment policies, but it's not covered by the ETS. So that was a crash course in the policy items that you're going to need to start drafting and implementing by the December 5th deadline. There are a lot of steps to follow and a lot of decisions that need to be made. So I would highly recommend beginning those discussions with your organization now. And with that, I will turn it over to Dave Detterding, who will be discussing OSHA's healthcare ETS.
Thanks, Colin. And I am going to give a very brief summary of the healthcare ETS requirements and its interplay with the new ETS so that we have time for questions at the end. So initially, the effective date of the healthcare ETS was June 21st, 2021. Covered employers was limited to employers providing healthcare services or healthcare support services. There were also a few healthcare type services that were exempted from the healthcare ETS. And as John mentioned earlier, this is important to note because if your company had employees or sites that were exempt from the healthcare ETS, it is possible that those employees or sites could now be subject to the new ETS that has just been discussed. And the exemptions for the healthcare ETS that was issued this summer included the following exemptions: telehealth services performed outside of direct patient care settings, the dispensing of prescriptions in retail pharmacy settings, healthcare support services not performed in a healthcare setting, and an example that OSHA gave was off-site laundry or medical billing. Non-hospital ambulatory care settings where all non-employees are screened prior to entry, and those with suspected or confirmed COVID-19 infection are not permitted to enter. Well-defined hospital ambulatory care settings and home health care settings where all employees are fully vaccinated and where all non-employees are screened prior to entry. Now, with respect to the main question that most people in the healthcare industry have asked us so far is how does the new ETS work with the healthcare ETS that was issued this summer? Well, OSHA actually has a Q&A on its website that answers this directly. The question was, does the current recent ETS apply to employees in settings covered by the healthcare ETS? And the answer OSHA gave was no. The ETS does not apply to employees in settings covered by the healthcare ETS while that ETS is in effect. Section 1910.502 was carefully tailored to the healthcare workplaces it covers and given the full suite of protections it requires. OSHA has determined that it adequately protects the employees covered by its requirements from the grave danger posed by COVID-19. Therefore, complying with the additional requirements of the recent ETS is not necessary to protect those employees while they are covered by that standard's protections. It will be necessary for employers with employees covered by Section 1910.502 to determine if they also have employees covered by this ETS. And then it goes into the examples of any employees or sites that may be exempted. So that's the interplay. With respect to state challenges, I just wanted to note that several states, specifically Arizona, South Carolina, and Utah, all submitted challenges to the healthcare ETS. Most of those issues are all still pending. They haven't been resolved yet. And I think Tennessee initially adopted the OSHA healthcare ETS, but their legislature has subsequently decided that they may want to back off of that. And so I don't know. It sounds like the new ETS is getting a lot more legal action more quickly, but in the interest of time, we'll move along. But just know that these things have been challenged before. What did the healthcare ETS require? It required that employers establish a COVID-19 plan, and they needed to get the input of non-managerial employees and their representatives in order to develop, implement, monitor, and update that plan. They were required to allow for vaccination leave. In fact, it said employers must provide paid vaccination leave during work hours and paid leave to recover from adverse effects. We'll skip through this. There was an anti-retaliation policy, record-keeping requirements, and there were also several different mandates from OSHA in the healthcare ETS in order to protect employees from non-employees, specifically patients who had been diagnosed with COVID-19. That included patient screenings, employee screenings, various requirements for PPE and various physical distancing requirements that included physical barriers as well as cleaning and disinfection and ventilation. All of this, OSHA goes into much more detail than we have time for now. Feel free to email me or any of our speakers if you have any specific questions about that, or put them in the chat, and I will open it up to questions now and turn it over to Amy Aslika.
Hi, everyone. Thank you so much for attending our webinar today. I know that we're running pretty short on time here, but I did want to just answer a few of the common questions that we're getting in the Q&A box before we finish up today. To take you back to the beginning of this webinar, which probably seems like a while ago to you now, one question we got was, with respect to VESSA, can you require employees to use PTO in conjunction with VESSA leave? Under both Missouri and Illinois' VESSA laws, you can allow them to use PTO or other paid time off, but you cannot require them to do so. Another question that we got is with respect to the OSHA ETS, if unvaccinated employees are subject to testing and masking requirements, can they remove their mask when they're in their cubicle? And the answer to that question is no. Per the ETS, they can only remove their mask if they are in an enclosed office, and the ETS defines this as 4 walls and a door. One question we got was, where can we figure out if our state is a mini OSHA state? As John mentioned, there are 22 states with OSHA-approved safety and health plans. Those states can be found on OSHA's website. If you just Google OSHA.gov state plans, it'll take you right to their website and show you those 22 states. Since we're running low on time, I won't list them all now. Another question we got is for employee requests about the number of vaccinated employees. Does it mean the entire company or just a local office? The answer to that question is it's just facility by facility. We've got a few more questions that we'll follow up with by email. If you asked a question in the Q&A that we haven't gotten to now, we will follow up with you via email, and I will turn it over to Susan to finish up our final housekeeping matters. Thanks, everybody.
Thank you, Amy. And I would also like to mention that we are doing a additional webinar on these new OSHA rules on November 11th at 10:30 a.m. Central. Please be on the lookout for the invitation for that, as we will be updating all of this information based on the status of some of the litigation that was mentioned, as well as a deeper dive into the rules itself. And with that, I'd like to thank you for participating in our webinar. Please complete and submit the survey that will display at the conclusion of the webinar, and have a wonderful day. Thank you.